So, good day everyone. Today we will discuss about the continuation of water resource planning and management about the legal and regulatory issues. By the way, my name is Joel Moral. So, let's start. This is the subtopics that we will discuss for today about the water rights to aquifer storage, the federal water quality regulatory. So, first, water rights. So, water rights can be given to a person or companies, but only the rights to use the water and not to own it. So, conflict between users automatically turn up at the table of the final owner of the resources or the government. So, if one's experience with water use in a water scarce coastal city, one might assume that it is desirable for water to be treated and reused before it is released to the ocean. So, however, in an inland environment, water use may affect downstream users of the effluent. Thus, the right to use wastewater needs to be examined. Thus, there are two distinct systems in US that law of water rights made. So, we have the water use under prior appropriation and the water use under the riparian doctrine. So when we say water scarce coastal city, it means that it is lack of water or water scarcity. So let's proceed to the water use under prior appropriation. So in accordance with each state's legal structure, treatment facilities planning to reuse water must consider the effect on downstream users. So, traditionally, wastewater has been considered a liability, and municipalities have used the least expensive means to bring the water into compliance with water quality requirements. So, effluent could be discharged. So, as communities expand, and treatment and monitoring technologies improve, wastewater in some arid regions is changing from being regarded as a liability to an asset. So, this evolution raises important legal questions of who has rights to be treated effluent and when and how the owner can use the resource. So, another perspective is to ask whether the use of wastewater constitutes a new water supply. It might in a region where flows otherwise are released to the ocean, so, but not in a region where downstream users relies on them. Next, we have the reuse under the riparian doctrine. So the riparian doctrine is used in the more humid eastern state and essentially bases the right to use rivers in proximity to the waterway. Hence the water rights resides in the riparian or the landowner, in contrast to the prior appropriation doctrine where the landowners who are not adjacent to the water source can acquire water rights. So the doctrine has involved with changing circumstances and modern practices. So it involves administrative requirements and the ability to transfer water rights. Generally, the wastewater operator would be able to rescue wastewater unless it would likely cause harm to downstream riparian rights holders. Next, we have the rights to aquifer storage. A reuse project may rely on a reservoir to store remediated water prior to its distribution. The rights to reservoir storage are well understood, so the project may own the land in the reservoir or may buy storage rights in reservoir owned by another. So if however the project relies on the ground storage, a different legal problem is presented. So the right to use of an aquifer to store water may be addressed to a statutory framework, in which case rights are likely to be defined. In some states, such as Arizona, Idaho, Oregon, and New Mexico, statutory schemes address when water may be stored and how rights to its withdrawal are governed. So, rights to store water in the subsurface are generally not controlled by the ownership of the overlying property. A recent case in Colorado explained why ownership of the overlying property did not create property right in aquifer below the property. Next we have the part of the legal and regulatory issues is the Federal Water Quality Regulatory. We have these following regulatories: the Clean Water Act and Wastewater Discharge, the Federal Regulation for Injection or Infiltration or Reclaimed Water, the Safe Drinking Water Act, and the EPA Guidelines for water reuse. So first, we have the Clean Water Act and Wastewater Discharge. So the Clean Water Act was developed to protect the health of the nation's surface waters, with states or tribes given authority to determine the uses to be protected. So we have the right to drink the safe and clean water. So the act established the basic structure for regulating discharges of effluents into the waters of the United States and for regulating quality standards for surface waters. So water quality standards are adopted by states and include water quality criteria, designated uses of water bodies, and anti-degradation provisions. So these waters may be protected to very high standards, such as the protection of a cold water fishery, or given lesser protection. Although the use of surface waters for water supplies can affect stream designation. Very few rivers in the United States are classified solely on their use as a drinking water source or a drinkable water. So states can take drinking water use into consideration in standard setting under the Act. So and other few who do so. So next we have for the federal regulation for injection or infiltration of reclaimed water. So numerous water reuse projects are subsurface injections or infiltrations as part of the wastewater treatment and storage process. So in some instances, aquifer recharge has additional purposes such as preventing subsidence or reducing saltwater intrusion into fresh water supply. So when water is stored through infiltration rather than injection, states and local regulation rather than federal regulation so addresses the quality of the recharged water. Aquifer recharged by direct injection in aquifer storage and recovery wells are regulated under the Safe Drinking Water Act. So next we have the Safe Drinking Water Act. So the U.S. Drinking Water Regulation sets standards that all drinking water treatment plants are required to meet, whether they use pristine water supply sources, supply water from potable reuse projects, or practice de facto reuse. So this section provides a review of the regulatory framework and the evaluation of its adequacy for potable use for potable reuse. So the U.S. Public Service published drinking water standards in 1962, which provides some insights into concerns regarding de facto or unplanned water use. Although the standards specifically state that the water supply should obtain from the most desirable source which is feasible. So the document goes on to state, if the source is not adequately protected by natural means, the supply shall be adequately protected by the treatment. Last, we have the EPA guidelines for water reuse. So The federal government does provide guidance to states via EPA's guidelines for water use, which presents and summarizes recommended water use guidelines for the benefit of the water and wastewater utilities and regulatory agencies. The APA in 2004. Regulations differ from guidelines, and the regulations are legally adopted or enforceable and mandatory, whereas guidelines are advisory and compliance is voluntary. So guidelines sometimes become enforceable requirements if they are incorporated into state regulations or water reuse permits. So what is non-potable or potable reuse? So just added to the topic, so let me explain about the non-potable and potable reuse. So potable reuse is for applications where direct or indirect reclaimed water contact is probable or expected, so and for dual water systems where cross connections are always possible. So disinfection to a level of detectable fecal coliform organism over 100 ml is advised based on the median value of the last 7 days for which analysis have been completed in any given sample. Also recommends that fecal coliforms not exceed 14 over 100 ml. So for applications where no direct public or worker contact with reclaimed water occurs, the guidelines recommend disinfection to achieve a fecal coliform concentration not exceeding 200 over 100 ml. So based on the median value of the last 7 days of analysis, it is noteworthy that the EPA guidelines for non-potable reuse applications are not based in rigorous health risk assessment methodology. So the World Health Organization in the Australia to have non-potable water reuse guidelines based on the risk assessment. So next we have the potable reuse. So potable reuse is the EPA guidelines provide some specific wastewater treatment and reclaimed water quality recommendation for potable reuse via groundwater recharge and surface water argumentation. So the guidelines outline the extensive treatment, water quality, and monitoring requirements that are likely to be imposed for potable reuse projects are based principally on California's draft groundwater recharge regulations and Florida's potable reuse regulation in place at the time the guidelines were written. The guidelines recommended that potable reuse projects meet drinking water standards, and also monitor for hazardous compounds or classes of compounds that are not included in the drinking water standard. So the EPA guidelines focus on the endpoint water quality differs significantly from the risk management strategies of the Australian potable reuse guidelines. So that's all. Thank you so much for listening. By the way, good day everyone. Thank you. That's all.